We're
The
live
agenda,
now.
this agenda item this morning is the status of trials. And I want to change that to the status of criminal trials. And then next Friday, schedule the status of civil trials. Because I've been reminded that trying to do both of them at the same time may not give us what we're looking for. So Chris Maley has contacted me, and I think Terry Corsones would like to be involved in that conversation, along obviously with Pat Gable and Judge Gerson, to talk a little bit about the civil process. So maybe we could arrange that for next Friday, Peggy.
Yep. Oh, let me. Sure.
Chris is with the Vermont Association for Justice, and he's been with us other times. And there may be other civil attorneys who would like to participate. I really wanted to, the focus this morning is on the criminal side anyway, with Matt and the state's attorneys and Judge Gerson. And yeah, so just make it the criminal and then we'll do the civil next week.
Yep.
Why don't I start with Eric to go over those of us on judicial rules, which is chaired by the able Senator Benning. But why don't we go over the I just got a text message that Sergeant Hall resigned from the state police.
What?
Sergeant Hall from Shasbury State Police Barracks, the one who was under suspension, has resigned from the state police. That's why I lost train of thought. I lost my train of thought. Eric, why don't we start with you to go over Judicial Rules Committee that Senator Benning is chair of, has been over the emergency judicial order, and that sets up this morning's conversation about the backlog in criminal trials.
Yes, thank you, Senator Sears. Eric Fitzpatrick with the Office of Legislative Counsel. Good to see everybody this morning. Here to talk a little bit with the committee about, as Senator Sears said, Administrative Order number 49, which is the order that the judicial branch issued that declared a judicial emergency back in March of last year. I'm sure everyone recalls that the state of emergency issued by the governor, I believe, was March 13th of last year. It was a Friday the 13th. If you look at, actually, I should ask first, does everybody have, I sent out AO 49, I think Peggy posted it on the committee site. So does everybody?
It's on the committee website. We got it this morning. But yeah, so we can refer to that. Good. If anybody wants it on the screen share, we could do that.
It's pretty straightforward, so I'll leave that up to folks. I can give you, as you mentioned, Senator Sears, a few minutes of background to kind of lay the foundation for the discussion that you're going to have with witnesses today. Obviously, AO 49 was issued by the court and not drafted by me, so questions about the details of the order will be probably better directed to some of the other witnesses you have on today, like Judge Grierson and Court Administrator Gable, who I think have a more familiarity with it. But I can certainly direct the committee to the language that's related to criminal trials, as Senator Sears indicated is the subject of your discussion this morning. So initially, the order was issued March 16th. So the executive emergency was declared by the governor, or the state of emergency declared by the executive branch, Friday the 13th. A couple of days later, on Monday, March 16th of last year, is when the judicial emergency was declared, essentially saying that due to the outbreak of the novel coronavirus, COVID-19, the governor's declared the state of emergency. For those reasons, the court thereby declared a judicial emergency as well, to go into effect immediately. That was that day, March 16th. Currently, as with the governor's order, the AO 49 has been amended many times, sort of in response to the evolving nature of the pandemic. When circumstances change, the rule needs to be amended to reflect sort of new knowledge and the new circumstances as they evolve. But currently, the Judicial Emergency Order AO 49 goes through March 31st of 2021. So right now, the date is extended through March 31st. That's been amended several times, the date, I mean. So that could certainly be amended again, but that's the current status of the rule, goes through March 31st. And as Senator Sears also indicated, there's a bifurcation in how civil trials and criminal trials are treated under the order. The focus today is on criminal trials, so I'll focus on that as well. The language in AO 49, and for those of you who are looking at it, this is subdivision 3 of the rule. 3A deals with jury trials and civil cases, which under the current language are suspended until the language says at least January 1st, 2021. So, technically speaking, civil trials under the language now, which is suspended till at least January 1st, technically speaking, civil trials could proceed under that language. With respect to criminal trials, the language is different. And it says that it provides the authority to schedule individual jury trials and criminal proceedings after January 1st, 2021, only with the authorization of the Chief Superior Judge and the court administrator. And I just realized that that also applies to civil proceedings. I hadn't noted that before. But so in either case, criminal or civil trials, the Chief Superior Judge and the court administrator have the authority to schedule and hold jury trials. But the rule specifically indicates some factors that should be considered in whether or not jury trials are going to go forward. And they basically are the ones that you might expect in a situation like this. They have to consider the current course of the COVID-19 pandemic, current recommendations of public health experts, whether the unit, the particular unit that the trial would be in, has adopted a plan that addresses ventilation and airflow and allows for socially distanced seating and movement of all participants and jurors through the course of the jury draw and the trial. So obviously you've got a specifically articulated factor that it has to do with the physical space in which a jury trial could take place. How well is it ventilated? Are there opportunities to keep members of the jury, the parties, the attorneys socially distanced? All that is specifically set forth as one of the factors that has to be considered when deciding whether or not a jury trial can go forward, as well as I just mentioned, what's the state of the COVID-19 pandemic situation? What have public health experts recommended? And lastly, the availability of staff and other resources to support court proceedings. So you've got that factor to consider as well. What kind of administrative support between the personnel who work in the court system is available to do that? I'm sorry, there was one more factor, and that's the rights and interests of the litigants. So also to consider what the parties themselves, what are their rights and interests in the moving forward with holding a jury trial. So again, that's not an exclusive list because it says that the factors to be considered include those factors. So there could be others that would also be relevant for the Chief Superior Judge and the court administrator to consider when they're deciding what to do about moving forward with jury trials. But those are specifically articulated and laid out in the list in AO 49. So that kind of gives, yeah, sorry.
That's fine. Just a quick question. One, has anyone challenged this? I mean, has any prospective litigant who's being denied a jury trial challenged this?
I'm not aware of that, but again,
I think there is a case in Bennington. It's always in Bennington, it seems, that somebody is, I believe, is challenging. He's been waiting on for a trial for quite a while. He was, I think he had a hung jury the first time, and he's still in jail. And he was concerned about his COVID-19 status, that he's a high likelihood, And, but I think Pat Gable or Judge Gerson can speak to that and may be able to answer that question about any other challenges. I know a lot of, we'll hear from the state's attorneys and the Attorney General. They've had a difficult time reaching plea bargains because there is no trial.
Yeah, Joe was saying that yesterday. Okay, thank you.
So the language as to sort of the considerations that go into whether or not to have a jury trial are just as I outlined, and that's really the base or the foundation under AO 49 of the factors that are going to be taken into account and what goes into the court's decision about this. I should also mention though, and you also have this on your on the committee webpage, and folks can take a look at it if you're interested in it, and maybe referred to by other witnesses later on. But when considering this issue of what to do about resumption of jury trials, the court and the judicial branch formed a committee. It's called the Supreme Court Jury Restart Committee, and that committee was tasked with coming up with not only and in fact, not just the factors to consider and whether or not to start jury trials, but what precautions, what steps needed to be enacted, what measures could be taken to ensure safety, to ensure efficiency, to ensure that the process would work, considering the COVID-19 pandemic. So that committee issued a report in July of last year, in July of 2020, which you have on the committee webpage. And that report dealt with some of the things that I've mentioned already, but really went into detail about what needed to be done with the physical plants, with the courthouses and the courtrooms, what measures would need to be taken to ensure safety, how the jury summons and the jury draws, as well as the trials themselves would need to be held in order to maintain safe practices during COVID-19, and any statutory or rule changes that might be needed to accomplish that. So there's a lot in there. It's a lengthy report, and I'm sure, as I say, Judge Gerson, Court Administrator Gable can refer to that in more detail, but it does, as opposed to AO 49, which we just looked at, which is sort of the factors to consider whether or not to have a trial. This report tends to go into more detail about if a trial did take place, what measures would be necessary to keep things safe.
I do remember reading that report, and there were places like Windham County was better off in terms of air and space than Bennington County.
Right.
And I know they recommended against Grand Isle County, and the folks in Grand Isle County saw that as trying to take away their trials. John Campbell, if you could mute yourself.
Oh,
or, thank you. No, anyway, that report is available. It's an interesting report. Is there any ability, and maybe I'll have to ask Judge Gerson that he can be prepared. When the House was looking at perhaps starting up, they were talking about using the Barry Auditorium. Could an alternative venue be used under the judicial order?
I don't think there's any prohibition on using an alternative venue, as long as it met the sort of criteria for safety that we were talking about. But as you indicated, Judge Gerson will probably know more, but I don't see any language that would prohibit that.
Thank you.
Yeah.
Other questions for Eric? Eric, thank you for setting the table.
Sure.
Did you have anything else? I don't mean to.
No, that was it. Thank you, Senator Sears.
What I thought.
Yeah.
Cheryl Alaverta is representing the Department of Corrections this morning, and thank you for being with us, Cheryl. Our main two things that we wanted to talk to the Department of Corrections about. One is, what are your numbers? And right now, in terms of both in-state and out-of-state placements and the number of people on detention, but also I'm hearing from defense attorneys that they're having, I'm sure others are as well, having problems and on long wait times to talk with their clients who are incarcerated. Is Cheryl there?
I am, yes, sir.
Oh,
Thank you.
sure.
Good morning.
Thank you, thank you.
Good morning. I was just looking
Yeah.
for my unmute button and my
Oh,
camera. So
that's how we all learn to live these days.
absolutely. We do Teams, so it's just a little different on this one. So
Oh, yeah, yeah.
yep, I did hear your question, and I am looking for this morning's email that came out about our numbers, which would give you today's information. Let me get you that. And then your other question was related to contact with
Difficulty
attorneys.
of attorneys, and I'm assuming others, talking with their clients who are on detention. It may also be clients who are incarcerated, but
Okay.
I've heard more concern from the defense bar regarding their ability to talk to their clients. Senator Benning can speak to that. He's one of the defense bar who's told me that he's had long wait times.
Sure. I can give you our numbers today to start with, if
Yeah,
that's
please.
helpful.
Yep.
So our total population is 1,286. Our out-of-state population is 184. So our out-of-state, yeah, it's pretty low right now.
Yep.
Our total male population is 1,208, and our total female population is 78. We have
What was the male population again?
1,208.
Yep.
And the female population is 78. Out of that 1,286, which again includes out of state, we have 308 state detainees.
That indicates, that was at like 400 before a year ago, was it not?
Our numbers were, yes, considerably higher on both sides, sentenced and detained.
Yeah, but the detained was about 400.
Yes.
Senator White.
So the person that you were talking about who's waiting for another trial, would he be considered a detainee because he hasn't had his final trial yet?
Correct.
Okay, thanks. Just wondered.
Correct.
Any idea of how many of those 308 are waiting for a trial?
I do not know that. I could get that number for you. I would think most of them are waiting for some sort of resolution of their case. Some of them may be sentenced, but for other reasons, but those 308 would be detainees waiting for some sort of resolution of their criminal case.
Other questions regarding the numbers?
I
are-
just,
Yeah.
not a question as much as
Senator
a comment.
Baruth, yeah, comment.
This goes back to when we were speaking at the very beginning of the pandemic about testing. And I asked, given that the numbers are so low, we're talking about, it used to be closer to 1,500. Now it's closer to 1,000. Why couldn't we test every inmate? And now the testing has ramped up. My question is the same about vaccination. It's such a small population at such high risk. Why not? That would be 2,500 shots would be 2 doses for the entire population. I just don't understand why the administration doesn't just do that. I mean, that's assuming that people would accept the shot, but any thought on that?
Are you asking me? I'm sorry.
Yeah, I suppose. I mean, it'll be a question that we can pose to other people as well, but do you have
I
any
think
thought?
Peggy and I plan to have the Commissioner of Health and the Commissioner of
Okay.
Corrections in to answer that next week.
All right.
Yes, I think that falls with the Department of Health for sure. Yes.
And
All right.
so we were going to ask, I believe that was one of the agenda items I asked Peggy to work on for next week.
Yep.
You can correct me if I'm wrong.
I just want to kick in. I think this is a good time to start planting seeds with the judicial branch, because we all need to be on the same page that the judicial branch right now is in trouble, especially with respect to criminal cases, and getting vaccines to the people who are in the court staffs, the judges, the lawyers, the prosecutors. And now Philip brings up another interesting component of that cohort. That's the only way that this system is going to move forward. And I think we all, especially the witnesses who are on this page right now, need to be on the same page, united in making sure that that message gets passed along to Dr. Levine.
We can add that to the agenda item for discussion with Dr. Levine. I don't know how you vaccinate potential jurors.
Right.
Because you don't know who they.
We may have to revert to having every jury panel over the age of 65 once they get vaccinated.
That would certainly be fair. And you'd be the first defense attorney to.
I'm only 64. I'll be in trouble.
Yeah, let's add that next week, Peggy, to that agenda item.
Okay, I was told by DOC today that the person we should talk to is Deputy Commissioner Jenny Samuelson from AHS, because they're in charge of it.
Okay,
So I'll reach out to them.
okay, that's great. Where were we? Okay, the numbers look really encouraging. But I'm wondering if once the court's backlog is taken care of, we'll see a surge. You know, people incarcerated who are currently in the community but are not incarcerated, and their trials come up or their resolution of their situation and they end up incarcerated. Senator White.
That brings up an interesting question, is if they are safely ensconced somehow in the community and being taken care of, would they really need to be incarcerated once the courts go back into session? I mean, is this an opportunity for us to look at who needs to be incarcerated and when?
I think that's Justice Reinvestment too is looking at that. Are you able to comment on the second part of the issue, which is the attorneys trying to get in touch with their clients?
Yes, sir. I think we have two conversations to have, and one of them is prior to arraignment, and then the second one would be after somebody is arraigned. And the easier one after somebody is arraigned is all of our incarcerated individuals have a GTL tablet, and they can have their attorney added to their PIN sheet, and those calls can be flagged as free and not recorded. So we have let the attorneys know that that's something that's available to them. If they want, their client can reach out to them that way. So as far as setting those calls up, it's not, they can't call their client would have to call them. So there's some logistics and how their client would know when, but that's easy for us to handle with our casework staff. But that is one way that it bypasses those phone calls, those phones and that are sitting in the units, where that's where the attorneys are having their problems with, because many of our facilities, the structure is set up that when the attorney calls in, it's one phone line. So if there's an attorney, a private attorney calling in and they're speaking with their client, and then an attorney from another county calls in, the line's tied up. So they cannot reach anybody else in the building. What we're working on right now with BGS is trying to upgrade as much as we can within our building structure, those phone lines. So that way we can have more of those available. But I think the bigger solution is for the attorney to provide their number to their client can add that number to their PIN sheet. And then we, as on our side, flag it as free and flag it as privileged. So it's not recorded, we're not listening to it, and there's no cost to the client.
Senator Benning.
So Cheryl, this is the first I'm hearing that such a device is available to an inmate. And that solution in isolation is ideal. But the practical implementation of it still sounds problematic. Generally speaking, my clients don't call me unless they have some immediate problem. But I need to call them on many different occasions for various reasons. And if I'm hearing you correctly, the way that this would be set up is they're provided with a number to call. But how does the attorney know what number they're supposed to call, especially in cases where there are new assignments and people are lodged either pre-arraignment or in some kind of a probationary status, they're revoked and they're placed back in the facility? How is it that we are supposed to know how to contact those individuals?
I think pre-arraignment, I'd like to sort of address those differently. I think if we're talking now about post-arraignment, people that have a tablet assigned to them, because pre-arraignment people will not have their own tablet. But post-arraignment, your clients would have their own tablet. And just like you do now, a lot of attorneys are calling and they're asking to speak with their client through the caseworker. It would be and like the same thing. They would call the caseworker and say, can you have my client call me Tuesday at 2 if that's when you're available? And then they would let your client know to call you Tuesday at 2, and then they could call you on their tablet, and that would be without using the attorney line.
So here's my problem. I get a notice from the courthouse that so-and-so has been assigned to me, and they are going to be arraigned on, say, Monday at 8:30. How is it that I am supposed to get hold of them if the lines that I normally would call the attorney line is present in the room where there is a current court hearing going on and we can't get through to that line anymore?
So can I just ask, are you all set with post-arraignment people as far as your contact with them and wanting to switch to?
I think that can be handled, but my immediate question and concern.
Understand. So pre-arraignment, we're working on a couple different options. Right now, we do have the caseworker or whoever at each facility is assigned to be the liaison to the court for those pre-arraignment hearings, the Rule 5 hearings. And they are the ones that are getting people, ushering them to and from those phone calls. Right now, in particular, I'm not sure, sir, I don't know which county you're from, I apologize, but I know at Southern State, because Marble Valley's closed, Southern State has multiple counties they're doing arraignments for.
Well, I'm in Caledonia County.
Okay.
And what my thought here is, in your immediate response, is that the caseworkers, is there any possible way when an individual is brought into the facility for the first time that a caseworker being assigned can contact the court, find out who the attorney is that's being assigned, and then contact the attorney to advise them as to how they can reach their client?
I think I can take that suggestion. I know that Judge Grierson and Defender General's office and the State's Attorney's office, we have regular meetings that we're talking about how to sort of solve these problems. And that's something we could certainly discuss at one of those meetings if there's another way. I know there's been the Defender General at that table too, to have those conversations as well. So I think we could discuss that in those meetings, if that makes sense. I don't think that I have an answer for you at this time.
No, as long as the seed is planted, I'm happy with that.
Yep, we've been meeting regularly on those questions. One of the things that we're working on at Southern State, again, we're working on with BGS to sort of upgrade the phone lines where we can. But one of the trials we're working on at Southern State right now is with those tablets. Not this, and again, if this is confusing, just please feel free to stop me at any time. But right now we have tablets that are assigned to individual people, and they have their own lists on it, and they call their own people. What we're working on right now, and we just got the list yesterday, the Defender General's office has been working with us to get us every single public defender and conflict attorney's phone number around the state. So they'll be added to these tablets, and then the tablets will be assigned to a county. So they'll be sitting at a facility, assigned to a county. Washington County will have one, and Chittenden County and Bennington County will have their own. When those arraignments are getting scheduled to start, those attorneys would call the facility and say, I'm ready to speak to my client. So the staff member, the DOC staff member assigned to do that would pick up the county phone for that, the tablet for that, and then bring it to the booking area where those individuals are, and then they could speak through the tablet with that. So they would call back on that phone line. Because again, those phones can only call out, they can't take calls in. So you or, public defender would call and say, I'm ready to speak to my 3 clients that are going to be arraigned. And then that tablet would be used to make that phone call. It would just be passed between those 3.
That tablet now in the booking area?
Correct.
The booking area, at least in my experience, is never a place for confidential conversations. Is there a problem there to be thinking about?
I think each facility is different, and I think it would depend on how, this is just one solution that we're talking about too. There's still the regular attorney lines that are in there that you have access to. So there are other avenues. This is just another piece to the puzzle we're trying to add to help with the solution for it.
Cheryl,
Yes.
it strikes me hearing you say that they're going to pass the tablet between them. Isn't that a COVID?
We have protocols for that, sir. Yes, we do have protocols in place for that, for cleaning the tablet in between each person. They won't just be passing it directly. It'll go
Okay.
back to the staff member who will follow our protocols to clean that in between each one.
Okay, perfect.
Thank you for asking.
That doesn't speak to Joe's point, but
No, but thank you for
that's-
asking that. That
Yeah.
does.
I'm not sure if Senator Sears has gone offline.
No, I'm
Okay.
actually here. I just had to do something.
Okay.
Did you have a question?
No, I just wondered where we were headed.
Yeah, I think we need to hear from others on this issue, and I thank Cheryl for her testimony.
I can stay if there's any further questions. I'll just mute myself
Okay.
right now.
I
Thank
think
you.
I'll go to Judge Grierson and Pat Gable in either order or both at the same time, whichever they prefer.
I think Judge Pearson could testify first, and I'm happy then to supplement or answer questions.
Okay, Pat, thank you.
Good morning, everybody.
Good morning.
And it's Happy New Year. It's good to be back before the committee, although like you, I wish we were meeting
Nice
in
to see you.
person. And
Yeah.
For the record, Brian Grierson, Chief Superior Judge, and I think what Pat was alluding to is after I testify, she'll come on and correct take care of any issues that I haven't properly addressed. Just a couple of comments before I get into the subject of jury trials. Senator, you asked about, or you commented on the numbers that Cheryl presented for the detainee population. And it struck me, as I saw those numbers, I get those numbers every day, that the total state detainee population, male and female, is down to 308. And if you recall, before the pandemic, historically, we had trouble getting below 400 on a daily basis. So I think one of the things that stood out for me was the fact that, despite the fact that, and I'll get into it, we haven't not had any jury trials since February of last year, 2020, excuse me, that detainee population has not grown. And it's actually down. The other number, though, that is, I think, probably of equal interest to the committee is the fact that of those 308, at least the last count I saw, there were a little more than 200 of them were being held without bail. And as we talk about the issues that are before certainly the judiciary and this committee, that population is certainly a priority population for the judiciary, as it is for everyone involved in the criminal justice process as we go forward. I will say, and I think you're all aware, that we have not had jury trials since February of last year. I am cautiously optimistic that we will be able to resume the work we have started in Windham County in February, meaning that we would hopefully be able to resume the process to bring in a jury in mid to late February in Windham County. The reason I say that is that we have, among other things, we've been working over the course of the pandemic with BGS, with the Department of Health, and we've also retained the services of a Dr. Aaron Bromage, is a immunologist, infectious disease expert out of UMass Dartmouth. And Dr. Bromage, we're able to retain his services in the fall, late fall. But he has been consulting with a number of New England states and with courts throughout the country and other businesses around the pandemic and the effects of this virus. Matter of fact, he was working on the virus actually in December of last year, before it was really publicly aware because of the work that he's done. He's been just a fabulous resource for the judiciary, for us, but for other states that he's working with. And if there's ever an opportunity for this committee to hear from Dr. Bromage, I think it would be certainly something I'd be glad to talk with the committee about. He's just a wealth of knowledge in this area. But I bring his name up because when I said I'm cautiously optimistic, we are awaiting word from him, hopefully this week or no later than next week. He indicated in a meeting with Vermont and other states last week that he's going to do a state-by-state, I'll call it an analysis, a summary of where we stand in terms of restarting jury trials. Vermont, like other states, have not been able to conduct jury trials, or some of the states have done it on a very, very limited basis. But based on Dr. Bromage's recommendation, jury trials, for the most part, were suspended in January. And the question before him last week, not only by us, but by other states that he's consulting with, is it safe to resume jury trials in February? And that's when he indicated he'd be providing us with a report. And it's hard because as I was listening to the news this morning, for instance, the numbers, as everyone knows, are up. The case numbers are up. That's certainly something he takes into consideration, the positivity rate. But the other, I'll call it, glimmer of hope from this morning's report that I heard was that although the numbers are up and we expect to see the bubble from the holiday period, at least the report this morning suggested, and this is a local report, that the numbers may come down by the early part of February. And as we're looking forward to resuming that work in Windham County, what's important about the next week to 10 days for us is that the jury panel that was summoned for that case, and I'll go back a little bit, it was scheduled for December 7th. So a jury has been summoned. We had started the process of considering jury requests to be excused. And so for us to get that case going again, or that court going again, we need about a month's notice. In other words, we always give those jurors about a month's notice. So if we can get clearance from the Vermont, as I said, we're working with BGS and Department of Health and with Dr. Bromage. If we get that notice out next week, then we would be able to resume that trial about a month from then, which would be mid to late February.
But it would seem that a trial would conflict with the governor's executive orders. How would you put 12 people together, not of the same household, not counting all the staff and everybody else? So do you, this is, and I would love to, I think we need to get jury trials back going, because that would result in a lot of resolution of many of these cases that are just waiting, for a plea bargain. But can you actually do that, or would it not violate the governor's executive order?
Well, it's interesting that you asked that question, because that played a role in why we suspended the trial date that was scheduled for December 7th. Because if you recall, back at that time, the governor was saying that certainly around Thanksgiving, which would have been a week or so before that, 10 days before that, that families shouldn't mix. And that's one of the factors we took into consideration, plus some protocol the court had adopted at that time, again, based on Dr. Bromage's recommendation that post-holiday period, 3 or 4 days after Thanksgiving, Christmas, and New Year's, that we minimize in-person appearances in court. So the combination of the numbers going up in December, the governor's order, which we obviously follow, and the Department of Health recommendations, that's why that trial was, or case was suspended at that time. So going forward, if it looks like the numbers are going down to the point where we can go back to where we were pre-Thanksgiving, we would send the notice out for February, but we're continually monitoring what is happening, so that if we, even if we send out notice to the jurors, and whether it's a week or whether it's even the day before trial is to start, things change, we're prepared to cancel the trial if necessary. We have worked, as I said, with the Department of Health as well as BGS, and in talking with the Department of Health, we've asked if we are ready to go forward, we would make sure they review our protocol and the steps we've taken to make the trial safe for the public coming in. And we would hope to get their, if you will, stamp of approval to move forward.
Now, would you take cases, for example, from Bennington County and Windsor County and move them to Brattleboro trials? Or is it planned just to do those counties where the state office building, or the courthouse is approved for air quality and et cetera?
So the short answer is, I've been asked that question many times about a change of venue. And when you think about it, the number I gave before of roughly 200 individuals held without bail, we would obviously have to look at a county by county breakdown of that. And I don't have that number in hand, but I know that it's available. Each county is going to have their own cases that are crying out for trial. There's no question. What we hope to do, we need to get a trial under our belt. We need to understand what it really means to try a case under these circumstances. And I would hope that with the reports coming in from BGS being responsible for the state courthouses, is the one that is providing us the data and information to be able to say, yes, we can do trials in Bennington or Windham or Washington County. So we're still awaiting those reports from BGS on many of the state courthouses, but I hope that by March we'll be able to open up more courthouses because the change of venue, although it's possible, it's then prioritizing perhaps a Bennington case over a Windham case. The Windham case court is the one that's moving forward now because that's the one we've been working with since July, since the report that you referenced earlier came out. And I can explain to the committee what's involved in standing up even one court. But I am hopeful that by March, we'll be opening up more courts so that that issue of change of venue, it's there, but I'm hoping that we're not going to have to go there, because then you're saying, setting up a criteria to say this case in Bennington is more important than another case in Windham or whatever county we're talking about. And that's where it becomes difficult.
One of the questions asked earlier when Eric was doing his presentation was if there had been challenges to the right to a speedy trial.
I'm not aware that a challenge has been made that has gone up to the Supreme Court. I know that I think very early on there was a challenge by a detainee over the COVID conditions, in other words, seeking to be released from a detainee population because of COVID. And I believe that went to the Supreme Court. I'm not aware Senator, I can find out, but if they're going on in the trial courts, they would have to obviously have a decision issued and then an appeal taken to the Supreme
I think
Court.
there was one in Bennington, and I believe Judge Valenti ruled that it, because of the pandemic, that it wasn't.
And I think I'd heard about that case, but the question would be then, did the individual appeal it to the Supreme Court? So
I
there
don't
has,
believe so.
right, and so I don't think that I know there hasn't been a decision issued by the Supreme Court as it relates to AO 49 and the lack of jury trials. That's not to say that, the longer it goes on, obviously, we expect that issue will be raised.
Pat, did you have anything to add, or are there questions for the judge or Pat Gable?
Before Pat jumps in,
Oh, okay.
I just want to give the committee just a quick snapshot of what it means to stand up a jury trial at this point. I've been in the trade, if you will, the business for going on 45 years. And one of my first positions was as the deputy state's attorney in Washington County. And the reason I wanted to do that was to get trial experience, courtroom experience. And whether it's me or Senator Benning or any other attorney or judge understands that the jury trial process, in its simplest terms, you bring in 40, 50 members of the community to come up with a group of 12 to 14 individuals that sit in a jury box that's designed for 12 or 14 individuals in a courtroom with a court reporter and a witness chair, generally speaking, all in the same place. There's a process. It's almost becomes routine for those who are involved in it every day. This pandemic has completely revamped that whole process. I mean, we literally had to start from scratch in opening up a court. And by that, I mean, when that jury restart report came out in July, I immediately put together a smaller group of trial judges to start that process of what does it mean to bring in a jury in this environment. And what it immediately meant was that in a court like Wyndham, where we normally would bring in 150 jurors or summon the initial summons, we doubled that number. And in doubling that number, we also required more time to process those jurors. We normally would go 6 weeks from the time we send out the first notice to a trial date. Because of the pandemic and the numbers involved, we moved that to 8 weeks, meaning it's 2 months from the time a notice goes out before that jury will come in. And so you can see, for instance, if we get the clearance to go ahead this week or next on opening up other courts, it'll be March at the earliest before those other courts are open. If you walked into the Wyndham Courthouse, and we were fortunate because Dr. Bromage was able to come to Vermont, and he was able to personally visit 4 or 5 of our courts, including Wyndham. And if you walked into the Wyndham Courthouse today, as opposed to what it looked like a year ago, it's changed dramatically. In other words, that jury box of 12 or 14 people, if the trial was sitting, there'd only be 3 people in that box in order to socially distance. The others would be scattered around the courtroom. We had to move the witness chair. We had to move the court reporter's position in the courtroom. We had to put up a different location for the counsel. In order for that trial to go forward in Wyndham, it was going to involve 3 courtrooms. Normally, the jury will go from one courtroom to a waiting room, if you will, a room where during a break in a trial they'll go for deliberation in a particular room. They might have lunch there. But for that trial, it was going to involve all three courtrooms in the Wyndham courthouse. They'd need the trial that had a courtroom that was going to be rearranged, as I explained. When they took a break, we would move them next door to to another courtroom where they could socially distance of 6 feet. But we wanted them to remain in the building during the day. And so we were going to have to make arrangements for lunch in the only room that was large enough for that many people to sit down eat and drop the mask and be able to converse, we needed the third courtroom. And ultimately what that meant was that any other proceedings going on in that courthouse that day would be moved probably to Newfane, the other courthouse in Brattleboro. So I just wanted the committee to understand that that's just an example of what it means to try to stand up a trial under these new conditions. Thank you.
Senator Baruth has a question.
Judge, I'm curious, on education, going back some months, we created an HVAC upgrade program, and we allocated $16.5 million to bring school districts' air quality handling up to the standard now required to mitigate the virus. Can you say anything about, I noticed in the administrative order, it talks about air quality as something that has to be considered. What is the general state of air quality in the state's courthouses? Does it need an infusion of CRF funds of that magnitude?
So, Senator, I'm going to give you the best answer I can, but having worked through some of these issues during the last 10 or 12 months, I was glad to know that, glad to appreciate the fact that I didn't go into engineering and stuck with law, because it is a complicated issue. But as noted in the AO 49, and as we've seen, and certainly from Dr. Bromash's advice to us, airflow and circulation is critical to providing a safe forum for these trials. I mean, what we're trying to do throughout this process is balance the rights to speedy trial due process that the litigants are entitled to, public access to the courthouses, and public safety by bringing in 50 or 60 members of the public in some fashion in a safe manner. And so the circulation is critical. The airflow is critical to that process. So I think one way of looking at it, and this is my own description, I'm looking at 3 tiers of courthouses. I start with the state courthouses, which are, BGS obviously is involved with those courts, and that we are waiting for their reports as it relates to the state courthouses. And there's no question that in some of those courthouses, we have had to increase the filters. There's terminology, MERV 8s versus MERV 13s, and what is needed to maximize the airflow and air circulation within those buildings. So clearly there has been a need to invest money in those filters to improve that airflow. What kind of money, I don't know off the top of my head, but that's certainly been an issue in some buildings. You then have the county courthouses that do not come within a BGS administration, and we've hired an outside source to come in and evaluate those buildings. Many of the county courthouses, as opposed to the state courthouses, have limited or no air circulation, no air conditioning, no air flow in that sense. And so that, I look at that as a 3rd tier of courthouses. We have not had anyone look at those buildings because under the circumstances in the middle of the winter with a closed building and closed doors and windows, we're just not going to be able to open up those buildings during this time. So we're looking at them at different issues arise depending on which courthouse you're looking at.
Well, the reason I ask is we have a second infusion of money and potentially a third on the way. And it seems like in all of those bills, there's going to be latitude to upgrade ventilation systems. The program that I mentioned in the school systems is currently still being run by Efficiency Vermont, and they were extremely efficient. They did $16.5 million worth of work in 3 months on hundreds of buildings. So I just throw it out there. that is an operation that is up and running, we might explore dovetailing it into these buildings that we're talking about. It would be, they wouldn't have the contacts that they have in the school districts, but they already have the contractors queued up, and they have the administrative procedures for spending the money. So it might be worth thinking about, rather than having them dismantle that program and start a new one.
There's no question that that's something that we should look into, because, as I said, the airflow, air circulation within the courthouses is key to our reopening those courthouses. So either Pat or I, or a combination of the two of us, will follow up on that. And I
Yep.
thank you for that,
Sure.
Senator.
I had to mute because there was a phone call in my background. Go ahead. Senator Benning.
Senator Sears, I plan to spend a little bit of time with the judge this morning, and I don't want to hog the conversation, but I've got several questions and some comments. If you need to cut me off at any point in time, feel free to do so. Judge, I'm curious about several things. I'm going to start out by saying I appreciate the obstacles that you have in front of you. And I don't want to minimize my appreciation for those things having to be dealt with. And I don't envy you your task moving forward. I do think, however, given the impression that the court system is virtually shut down, especially in the criminal arena, we have to start formulating a game plan moving forward where we all appear to be delivering a very concrete series of steps in order to get things moving again. I don't want to quibble about whether the public perception is out there. I'm just going to tell you that from a defense attorney's perspective, my filing cabinet has quadrupled in the number of files that are stuck. And I know I am not the only one in the criminal world that is actually feeling that pinch, because the last vestige, sorry about that, I'm in downtown Lindenville. The last place that we have leverage in getting cases resolved is the virtual threat of a jury trial about to proceed. And that's where the prosecution and the defense and the clients of the defense bar actually finally sit down and face off and resolve cases. We haven't been able to do that. And every single day is getting more and more frustrating because we haven't been able to have that kind of forced leverage, if you will, getting cases resolved. So I have some suggestions that I will start with. We have to establish a plan that we all agree to. I'm sure that we all agree to steps that you are taking in order to open up courthouses. But here's a couple of suggestions. I think that the judicial branch has to start pestering the executive branch immediately for recognition that you are a frontline group of people that need to be vaccinated. There isn't any question that the judicial branch of government is stuck in a holding pattern and will not be able to give people their constitutional rights unless and until we get to a point where the people working inside the buildings are comfortable in being there. As far as commencing jury trials, I think Senator Baruth had a thought, and I'm growing more and more in favor of that thought. There is now a targeted population that will be receiving the first doses of this vaccine. That population should be the first targets for jury trial participants. And there may be all kinds of reasons why that's not a great idea or whatever, but the conversation about that should be in the middle of all of this, because it provides the public, at least, with an understanding as to how you're taking steps to move forward to solve this crisis. I've got a series of questions that I'd like to know about that deal with Administrative Order 49.
Wondering, I need to get to Joe. I would like to hear at least from comments from John Campbell and Matt Valerio this morning, and we've got about a half an hour left before we move on.
I can
I wonder,
suggest,
yeah, if there's a,
Senator, if Senator Beneding wants to, I apologize for interrupting, but if he wants to put some questions in writing to me, I'll be glad to respond to those. And if necessary, I can come back at another date to respond to those questions before the whole committee.
I think the issue regarding the vaccination, I think we were gonna
I can
take up next
respond.
week.
Senator Sears, I apologize for interrupting, but I can respond to the suggestion of Senator Benning that we be in touch with the executive branch. The Chief Justice and I did contact the executive branch several weeks ago when the vaccine rollout was first announced, and inquired as to how we would best be in touch with the Department of Health regarding bringing the issues of the frontline workers in the judiciary, which would be security staff and judicial officers, to a place of priority. At that point, we contacted them so early, I don't think the Department of Health had developed a plan yet. And so we've been waiting to hear back. But informal is not prioritizing by individual characteristics.
You're
So I
either
just
I'm
wanted to
freezing up or
reassure
you
the
are. I'm
Senate.
not sure who's.
I think it's Pat.
Yeah, it's Pat.
So I've taken my video off. Is that better?
No,
Not
Is that
much.
better?
that's better.
Not better, okay.
Yeah, keep going now,
Okay.
Pat.
Can you hear? Okay, I'll try.
All
So,
right,
so we,
Pat, I'm going to jump back in and say,
should I keep
I
going?
think I have the gist of what you're saying, and I'm going to suggest that it's time for all of us to do the same again by contacting the administration and all act in concert, because this system is in a state of frozen animation, and we need to unfreeze it. And we can't do it with a magical brush. It's got to be done piecemeal, but we've got to have a plan.
Peggy has the name of the person from the administration that we need to hear from. And I thought we were going to hear from them next week. And Peggy, if you would add to the questions for them is, what are the possibilities of having the inmates, guards, judicial officers, including attorneys and so forth, in the vaccination schedule? So that's, I think, the question that Senator Benning has raised.
Nick, I think the remainder of my questions to Judge Grierson are probably going to be asked by Matt Valerio and John Campbell. So I'm going to back off from the rest of my questions for now. And Judge, if I don't hear them asking the right questions, I'll send you a personal note.
Right, thank you. I'm
Matt?
glad to respond.
I was going to say that I'm happy to yield to Senator Benning to give him more time for questions. A lot of what I'm hearing here is the type of thing that I would be talking about already, but whatever you'd like.
No, I need to end at 10:30. That's all. But go ahead, either one of you.
I'll let the senator ask the questions he wants to ask. I'm not, in these meetings, I'm not typically asking Judge Grierson questions, so.
True.
I'll try to make it as quickly as possible. Judge, according to the administrative order, there is a procedure for a defendant to request authorization from you for a jury trial. What is that process, and where is that procedure available for us to understand? Is it in existence? Question, is there a process that is in writing that instructs us on how to approach you or the court system in general for permission to go forward on a jury trial?
The process, Senator, would, in my view, would be you would apply to, if you're in Caledonia, you would apply to the local judge to say, a motion for speedy trial. And then the judge would have to rule on that motion and bring it to my attention. But I mean, I think the issue is right now, for instance, Caledonia is not a court that so far has been evaluated and approved to go forward. So the process is one where under the jury restart plan that you saw, the individual unit, if you will, Caledonia, between the judge there and the staff would submit a plan to me for approval of a jury trial in that court. Now, some of the courts have provided me with a plan awaiting the evaluation from the BGS, for instance, in Caledonia. Others are waiting to get that evaluation before they submit a plan. So depending on which unit I'm talking about, it's going to be a combination of the unit plan provided by the judge and the staff, and that report from BGS in the state courts, in order for me to say, okay, this court is ready to conduct a jury trial.
So if I understand you correctly, if a defendant asks for a speedy trial, which is their constitutional right now in Caledonia County, that would not be available to them. Would that be fair to say?
That would be fair to say.
Okay.
But
Is at this time,
let me say this, Senator. Again, that motion has to go before the sitting judge handling that, and however they rule on that. What I'm saying is when it's not available, that court at this point has not been approved for jury work. So how the local judge handles that issue, I would leave to them, how they address it within the context of a motion for speedy trial.
I just want to be clear about the process. Right now, the Caledonia Courthouse is not available for jury trials. So even if I brought a motion before Judge Harris, who's currently sitting there, it is inevitable that he would rule. It's not going to happen, Benning. That's just the way it is. And I don't want to leave the conversation with some kind of an impression that there is a process for defendants to be able to get a speedy trial right now in Caledonia County, because it is just not possible. There's no blame to lay out there, but it's just not possible. I want to know how a pro se defendant, for those of you that don't know what that means, they're representing themselves. A pro se defendant would have to go through the same process. In other words, they'd have to petition Judge Harris for their speedy trial. How would they understand or get to the point where they recognize that even if they approach Judge Harris right now, it's not going to happen? How would they know that?
Well, that just, highlights the issue of self-representation. As you know, a self-represented litigant is bound by the same rules and procedures that you as an attorney are bound by. And so they would have to, for instance, make sure they've looked at the Judiciary website where they will see AO 49, where they will see this jury restart report. I mean, they would have to avail themselves of the same information that you have in advising your clients. But they would, again, have to start that process by a motion for speedy trial that goes before Judge Harris. Now, Judge Harris, every judge is independently appointed, and they can exercise their discretion on a particular case, and whether they deny the motion because the court isn't available or agree that the defendant is entitled, that's where that decision has to be made at the local level.
I don't want to leave a hanging chad, if you will. My understanding is that if a petition is brought right now to Judge Harris, you would have to literally tell Judge Harris, if he approached you and said, what do you think, that the Caledonia County Courthouse is not available for this process.
That's right.
And the only logical conclusion I can pull from that is the motion will be denied. So the next question would be, is a speedy trial right under the Constitution has some components to it that the Supreme Court looks at in deciding whether to approve of such a motion. One of which is, has the defendant taken affirmative action to request a trial? And I'm worried that this time, when people already know they can't get a trial in Caledonia County, I don't know why they would bother to send in a motion for a speedy trial if they know that. But if they don't, is that going to be taken against them in a determination of whether or not they effectively acted affirmatively to have a speedy trial?
I think you've come about as close to asking me for an advisory opinion as I can't answer that, Senator. I understand the issue that you've raised, but I don't think it's my place to be able to answer that specific question.
Okay, I submit that we owe that answer to the public at large. I understand all the problems that are associated with it, but I submit we owe that answer to the public at large. There's probably a lot of other questions I could ask, Ron. We're going to cut it off because I hear you needing to move on, Dick.
Well, it's not just moving on, but I think it is at the heart of there's two issues. One is people are being held without receiving a trial, who are not able to either make bail or I have no bail. They're held without bail. So that's one issue. You have 308 people that are on detention. Their ability to get a speedy trial is not possible. We've heard the reasons why, and it would violate the governor's executive order as it is now to try to do that. Now, maybe Windham County can hold a trial, but that doesn't help my Bennington County. So one of my questions is about other venues, if that's been considered. I think I raised that earlier, and that, for example, the auditorium in Barry was going to be used for the House, but they chose to continue remotely. Could that be used for a jury trial? Those are the questions that I think I'd like to have. Maybe if the judge wants to come back with answers, but I think your question is asking for an opinion. It'd be like going to the Supreme Court. I don't know what the status of Judge Valenti's ruling on the Bennington case is. Maybe either Matt or John know.
Dick, I want to just jump in with your comment about the 300 that are incarcerated. There are thousands of other individuals out there whose lives are on hold. They're not incarcerated. But when I have a client walking into my office right now who wants a jury trial, I have to look them square in the eyes and say, you know what? You can have a jury trial, but it's probably going to be about 4 to 5 years down the road before you get there. And a lot of these people are subject to rather onerous conditions of release, like a 24-hour-a-day curfew requirement. So it's not just those who are incarcerated that are in serious trouble here. I just wanted to make that point, that there's a whole lot of other people out there, many, many more than just those 300.
Do we have any idea of the numbers?
I don't, and that's a question I was hoping to get answered today.
Number of pending criminal cases, is that what you're asking?
Yes.
Yeah.
Yeah, I don't have that number, but I can certainly get it.
Can you get that for next week?
I can get that to the committee. I will say that, and I know that you've got other witnesses, I will say this. We need to open up these courts. I recognize that. When we do open up these courts, jury trials are going to be the priority, meaning that where a court normally might have 3 or 4 days a month devoted to jury trials, we've got to double that. We've got to make jury trials the priority. And so that's going to have an impact on defenders. It's going to have an impact on the state's attorneys, but we have got to make this case and the population you're referring to, Senator, of people detained and even those on conditions of release. But the priority, in my view anyway, would be those who are held without bail. The next would be anyone who's held on bail. And then we'll get into the trials on cases where individuals are out on conditions of release. But the priority has to be with those cases. And if necessary, where I can, I anticipate bringing in retired judges so that when we do a draw, we will have judges available to take pleas on one hand, but when we're bringing that jury in, we're bringing that jury in to try cases and to move cases. And I appreciate what Senator Benning has said. I know from experience, both as an attorney and as a judge, that nothing moves cases like the potential for a jury trial. And I understand how important that is. And when we open up, we're going to do everything we can to make those cases and that docket a priority.
Thank you, Judge. I wonder if I could hear from John Campbell briefly, and then we will need to discuss this further clearly next week when we get more information. I think the Department of Health or the Agency of Human Services will be able to provide some of our answers to the questions. Executive Director Campbell, right?
Now, Senator Booth, you should not be laughing. You know, there's been other things that have happened in these strange times in the last 10 or 11 months. So, first of all, thank you very much for having me testify today. And everybody that's spoken today, from Judge Gerson and Senator Benning, are absolutely correct. And you know, we've got a major problem on our hands when it comes down to when the doors open up again. First, I'd like to address quickly. I'm looking. I've got like 10. There's only 10 minutes for your 10:30 break. But the vaccination. One of the things that it's a good idea as far as if you do have a jury trial. Let's see about getting all the court personnel and jurors vaccinated. But there's still a question out there as to whether the person even vaccinated, whether they can still spread the virus. So there's some other questions that need to be asked there. You know, a big concern we have, I have had many conversations with our state's attorneys and addressed the issue of the backlog, and everyone knows it and everyone realizes that they're a problem. And we've been doing everything we can to make really flexible offers out on cases right now. And the defense bar, I'd say for the majority and the most part, they're not jumping at any offer right now because they realize that the chances of their clients getting to trial it's going to be slim next to none, especially misdemeanor cases that probably won't happen for at least a year with the backlog. So, and of course, a defense attorney has the obligation to their clients to try to do the best for them representation-wise. But we are trying to do what we can to get these cases settled. What we found the best way, and actually Senator Sears, and it was in Bennington County where they had some of the retired judges come in and have, there weren't official judicial conferences, but they had the meetings between both parties with the defense and the state's attorney to discuss the case and to see about trying to mediate some type of resolution. Those are working really well. Erica told me that she found it to be extremely helpful, and they were able to clear a lot of cases. Now, my understanding was that the court administrator's office was going to, they had the COVID money to bring in the retired judges. So I would ask them and also advocate that they try to make sure that the other counties are doing the same thing. One of the things we're finding is that there's such an inconsistency throughout the state as to what the judges, some judges will make sure that the hearings continue on. Some are asking for in-person hearings, but others are not. And in fact, there's a couple of counties that have delayed the all arraignments until June. And that's just going to continue and the backlog. So I don't, Judge Gerson, he and I have been talking, and he was going to get back to me on the arraignment issue. But those are serious issues, because number one, for the defendant who's sitting out there and not knowing what's going to happen, but also for when the court's open. I can tell you straight out, and this is not, I'm not leaking any information to the other side that they don't already know, but we do not have the personnel to be able to handle these cases, because it's not when you do a trial or even just handling everything else, because all of the other normal cases will continue on to come into the offices. Right now, we have in the offices, the state's attorneys, they have, most offices only have one secretary and one administrator. That is not enough to help. And the fact is that when you have just 2 attorneys or 3 attorneys in one office, and the caseloads are up now, getting 300-400 cases for them by the time that this comes around, they're not going to be able to handle it. And I think the defense is aware of that. And unfortunately, we've got to do something about it. And I don't have the answer at this point, but I can tell you it's going to be a resource drain on us, I think on the judiciary and also on the defense. So I think I kept my promise, Senator Sears, and I get my.
Yep. No, I appreciate that, John. We've opened up a can of worms.
Yeah.
Thank you, Senator Benning, for raising the questions. Matt, do you have anything to add at this point? Matt Valerio.
I think the biggest thing that I would want to talk about in the couple minutes that I have, and I was asked in the House Judiciary Committee yesterday, what are you doing about getting people trials? And I said, there's an honest reality here, is that I don't know that there's anybody in the justice system who can do anything about getting anybody trials until everybody is vaccinated. That is going to be the thing that brings us out of this. I did some research about what they did with trials during the Spanish flu in the early 1900s. That they had some outdoor trials during warmer months, that kind of thing. But aside from even something like that, I don't see how infrastructure-wise Vermont is physically capable of providing safe trials for everybody who has to be involved until vaccinations take place. I concur with John Campbell in that what is happening right now, while our detention numbers are not enormous, and frankly, having the numbers on a Wednesday, they're probably a little lower than what they would be if you took the same number on a Monday. You're easily down 50 to 75 compared to that day. So our numbers they're clearly not as high as they have been as a pending number, but they're not as low as they show today, I don't believe. The biggest issue, though, is that we've got all of these cases that are building up that aren't detained. I mean, if you have a misdemeanor case, you're literally talking about years and years before we get through to those cases. If you're going to have a trial, or even motion hearings, because there's limited number of judges to hear those things. So to me, there are 2 stages of this. One is opening, and that opening is going to require us, I think, to have vaccinations. My Wyndham office sent me an email last night that said, I know they're looking at us again for potentially opening for jury trials. Then they went through a list of our immunocompromised people who work in the Wyndham Public Defense Office. And the managing attorney said, I don't think we can do trials unless we have vaccinations. So that's going to be one stage. And then the next stage is, once everything opens up again, we are going to deal with these pending cases that Senator Benning was talking about going forward. Now, you can only push so many cases through so many judges. So backlogs are an interesting thing when they're pending cases, because you can't try 2 cases at once. You can only try however many you can try. I will say, to try to quickly answer the issue about filings around the state, I know there have been speedy trial motions around the state filed. They've basically gone nowhere. And at the trial level, the biggest issue is that nobody has an answer of how to deal with it, even if they went forward and said, yes, I'll give you a speedy trial. Now what? Because there is nothing to do. Effectively, I think that for trials, the entire state is shut down. I will say that it is not for lack of effort with the people involved. Judge Grierson, interim Commissioner Baker, myself, Cheryl El Lavorda, I always say her name wrong, Dale Crook, Al Cormia, and others from corrections have routinely been getting together to work on like the communication issues that she was talking about with arraignments. And they're not resolved, but it takes a little bit of time to put in brand new infrastructure to try to work these things through. In the meantime, what might be a month of working on things for us in government sounds like not that long a time. But if you're sitting in jail and you can't get a hold of your lawyer, that's a really long time. And it's a very difficult thing to deal with. It's not for lack of effort by anybody involved to try to resolve this. But I honestly think the only way we're going to open the courts to trials is by vaccination. And as far as I know, right now, public defenders, prosecutors, and court personnel aren't really even on the list.
Well, I think next Friday, we'll devote next Friday to both the civil trial issue and this issue with the Agency of Human Services. But both you and John Campbell and Senator Benning have made us more aware of the huge numbers of people who are charged with crimes who may be awaiting resolution of that could go on for years before their backlog is addressed. And that is, I can only imagine if I were charged with something I didn't think I was guilty of, and not being able to get it resolved for years.
Well, I do think that there comes a time when, and I've been researching this and talking to our appellate division about it, where we are going to be looking for the mass dismissal of hundreds and hundreds of misdemeanor cases, particularly, that are going to be sitting for very long periods of time, witnesses disappearing, defendants potentially disappearing, complaining witnesses disappearing, evidence not being available, all of the things that are potentially contemplated. There's Criminal Rule 48B that allows for dismissal of minor cases depending upon a whole number of circumstances. But this isn't anything anybody anticipated, but perhaps to free up the system to focus on the more important cases in a meaningful way, it's going to require the resolution by dismissal of hundreds and hundreds of minor cases.
Thank you. Peggy, could you and Eric work with Matt and John Campbell and Judge Grierson on the questions that we have for the Agency of Human Services so that they're clear as to what we would like to talk about next Friday?
So are we going to have them come in this Friday on the vaccine rollout?
No, next Friday.
Okay,
a week
so you
from
want
this
to take,
Friday.
I'm sorry, say that
A
again?
week from this Friday, we would do the vaccine rollout, the civil trials, and a little more on the criminal trials. The civil is a completely different, but they're backed up tremendously as well. So I just wanted the agency not to get taken by surprise by the questions we have. Much of it is the order of vaccination for people within the criminal justice and the trial court system.
Yep. So we did have it on the agenda for this Friday. So you want me to take that out, right? We had it from 10:45 to 11:30.
Oh, we did this already? Oh, okay.
did, but
Yeah,
I
this
haven't-
Friday's fine. Yeah, this Friday's fine.
Okay.
I thought we'll do the civil trials next Friday. But the
Okay.
criminal, we can hear from the agency. Yes, Senator Benning.
I want to reach Judge Grierson and John Campbell before we go, in the spirit of trying to decrease some of the court backlog. There has got to be an explosion lately of modifications of conditions of release of people who are not being held, but are being subject to things that have totally disrupted their lives. If there's any possible way, John, in your case, to simply pass a message out and say, guys, take a deep breath and think twice about the conditions you are seeking to have imposed. They may end up doing it anyway, but that's a message that they really ought to have. And Judge Grierson, I pass the same request along to you, that when judges are looking at these conditions of release, they also take a deep breath and decide whether or not this is critical in this particular case. Because my cases have just blossomed in modification petitions, and that can only be clogging the court system if I'm not the only one faced with that.
Senator Benning, you're preaching to the choir. In my opinion, there are only two conditions of release that have any merit, and that is no weapons or firearms, dangerous weapons, and no contact in the given case. For the bulk of the conditions we're just fooling ourselves if we think that imposing a condition that someone that hasn't had a license for 10 years, and we impose a condition that they shouldn't drive, is going to change their behavior. But those are the kinds of cases that are building up because of these conditions. If there was ever a time to not impose the so-called standard conditions, it is now, because we are just building cases that are essentially, we've made them crimes. If someone is driving without a license and they're stopped again, that's the crime. By adding some of these other conditions to it, it's endless. And where we see it, and I don't want to take up the committee's time, but last year we spent a considerable amount of time talking about surcharges. I have seen cases with 3 pages of a plea agreement that everything is run concurrent, and there's 10 conditions of release violations that there's no sentence imposed, but each one of them carries $150. Someone walks out of that courthouse with $1,500 worth of surcharges. I agree with you.
And Senator, I'm more than happy to pass that message on. Yeah, Senator, I'm more than happy to pass that message on, and I think it's a good one. Again, as you know, that we're not the ones that make the decisions on the final decisions on the conditions. But
if those that are in the meeting now can be available on Friday morning at 10:45, when we hear from the Deputy Secretary of the Agency of Human Services in charge of the rollout, might be appreciated. Thank you.
We'll be there. Great. Thank you, Senator.
I've got to take a break. Marley's calling for my, you may hear him in the background. So we'll be back at 11. I mean, excuse me, at 10 of 11. 10 of 11. Okay, thank you.
Be sure to mute and shut your video off thing.
Sarah,
Yes.
hey, I got your email
Great.
and I'm happy to sit down. I forget, did you suggest a time or were we going to work out a time?
I suggested Friday at 1:30, but I don't know if that works for you. Otherwise, I can
No.
send you other time.
Yeah, I'll be in committee then.
Okay. Let me circle back with David and find some time that works on our calendar, and I'll send you some times for next week.
Okay, great.
Okay, thank you.
What else is going on these days other than insurrection and plague, Joe?
Well, I get the feeling that I've joined you in the having a proverbial target applied to my back.
Well, so much fun.
Yeah. Don't worry, we're going to be saved by people like TJ.
Good morning, Senator. How are you?
Not bad.
Saved again by people like TJ.
Hey, Philip. How are you? Good to see you.
Good. Good
Happy
to
New
see
Year.
you.
Happy New Year, guys. I'm
Mhm.
having technical difficulties again. I couldn't get on my God. Between getting on Zoom with my office computer and getting cell coverage is like a daily just hurdle and obstacle. So now I'm on my wife's computer. So if it shows up as Jessica, that's who I am.
I don't know if you got the same problem, but when I have to deal with the administration, I'm on, what is it, Cisco WebEx or something?
Yeah.
And this is Zoom, and then you go on to the court system, and that's a completely different format. I can't keep my head straight on which one has the button in which location on my computer to access things, and it's just a mess.
Yeah, it's really frustrating, and it's a daily daily issue.
When I'm on the court system, Judge Harris here in Caledonia County, he's wearing a mask, and he begins every session by shouting into the microphone that he's not shouting because he's angry. He's only shouting because he's got the mask on and he can't take it off. And people have trouble hearing him. The defendants can't be heard when they're in the jail cell. And
yeah,
it really does get to be crazy. And then you got other people calling in for their hearings, and they're just busting in saying, "Hi, I'm so-and-so. Is this for time for my hearing?" It's just a zoo.
Yeah, that's not good. Okay,
I just was reminded we're live on.
Oh, that's good to know.
On
so
YouTube.
I was just able to get on my work computer, so I'm actually going to try to jump off this and use my work account. So I will be right back, guys.
Alice, how are you doing? Oh, I can't hear you.
Do you mean computer-wise?
Well, just in general, we haven't had a chance to say hello, really.
Nice to see you, Philip.
Yeah.
Glad you've got the new position.
Yeah.
Several.
No, I am so happy to be on appropriations. I was wishing like a kid on Christmas.
You may regret that decision as they work late into the night toward the end of the session.
Yeah, but I think finance might be worse in that way. Do you think, Alice?
I have never been on finance, but they're there a lot of hours also.
Mm-hmm.
A lot of hours, yeah. And so are a lot of the committees now, really.
Although now it just means you're just in your house.
You're in your house with everybody complaining about get off of Zoom or get off of whatever you're on. Can you come and eat dinner, or can you?
Well, it does change.
Can you take care?
Yeah, the thing that was always kind of scary about appropriations was that people would ring the room, not only inside but outside. There would always be this scrum,
Yeah.
and of people trying physically to monitor what was going on. So at least there's not that feature for the moment.
Right, right. That's for sure. Yeah.
So you can't be on 2 Zoom meetings at a time, I just found out.
You could on another computer.
Well, I just had to get, hold.
You could open up another Zoom account. I would guess.
Senator White has just muted herself.
She's on her other meeting.
Yep.
No, she muted herself because she had to answer a question here, but so Calvin from CIX just called me and said, do you have 5 minutes to just talk about the town meeting bill? So I went on his Zoom invite and then I got kicked off this one.
Oh, yeah.
Dick Sears, thank Marley for the break.
You're welcome. It's FedEx was here, and
And Marley was enraged.
right.
Like,
So yesterday we had in our committee, one of our witnesses, all of a sudden there was this shrieking in the background and she said, oh, my 2-year-old is yelling because the dog is eating her mac and cheese.
I have to say, I haven't, in all the Zoom we've been doing, there haven't been that many fails, you know, with kids or dogs or, I mean, knock on wood, but, you know, it's been pretty buttoned up in a certain way.
Yeah.
Couple of swear words here and there. But other than that, it seems like it's worked pretty well.
you know, if you're good at shutting yourself off and also the mute, then
Yeah.
things don't come across the airwaves, so to speak, that
I think Ginny has the distinction so far of the worst on-air incident. And that was really only one word. So
We have good time, which is S18. And Eric is going to briefly walk us through the bill, and then we'll hear from Attorney General Donovan and some others.
Shall I go ahead, Senator Sears?
Yeah, please.
All right, good morning again, everybody. Eric Fitzpatrick with the Office of Legislative Counsel here to walk the committee through Senate Bill 18, which is an act relating to limiting earned good time sentence reductions for offenders convicted of certain crimes. I know that the good time concept, which remind the committee for a moment, is basically in concept the idea that an inmate or someone under Department of Corrections custody is able to earn reductions in their sentence through good behavior, essentially through complying with DOC rules, not getting charged with any new offenses. So essentially, they're able to reduce the terms of their sentence by engaging in that sort of good behavior. It's a topic that the committee has looked at quite a bit over the last couple of years. So don't think I need to give too much background. I think everyone's pretty familiar with it. Just for a moment, it's historically interesting to remember that Vermont had this good time system for almost 40 years until it was repealed in 2005 as part of the truth in sentencing statutes. But it was in place for quite a while, and then it was then not on the books anymore from 2005 until just 2 years ago, 2019, when you enacted Act 56, S112, which you worked on quite a bit in this committee, and you reinstituted this good time system 2 years ago. The program is in place now in statute at 28 VSA 818, which is what S18 proposes to make some amendments to. So what amendments are proposed in the bill? What changes are proposed to this new good time program that you put in place a couple of years ago? It's helpful just for a moment to look at the existing language in section 818. I know folks have the bill in front of them. If you look at page 2 of the bill, subdivision B1 lines 3 through 8. That's existing law, and that's what the proposal is to basically put some limitations on the nature of who can participate. So that's the proposed amendment in S18. It's in existing law. You see the language says the program's available for all sentenced offenders, including furloughed offenders, provided that it's not available to, and then it goes through a list of a few categories of folks to whom who cannot participate in the good time program. They are people who are on probation or parole, eligible for a reduction of term pursuant to 811, or, and this is the key language here, offenders sentenced to life without parole. So there is a small group of offenders based on the crime that they committed who are not eligible for participation, but it's a small group, people who are sentenced to life without parole. Senator Sears, I see Senator Benning waving his hand there, so I just pausing for a moment.
Yep.
Eric, given the platform we are on, are you able to pull up the bill and share it with us as we're speaking about it?
I think so. Peggy, are you able to do that by any chance from your end?
It's on the documents on the website, Joe.
I do understand that, but most of the public who is watching this doesn't have that kind of access or to computers like I do.
Eric, I just made you the co-host so you can share it.
To me, Peggy, did you say that? Sorry.
Yep, I just made you the co-host so you can share it.
Okay. Yeah, that's not functioning from my end at the moment.
Okay.
I don't, sorry, but they'll have to go to the website for right now. Well,
Okay, I'll come through this and then I'll circle back around with Peggy to see if I can share it after I do the quick walkthrough.
Would you like
But the point here is that as currently on the books, the good time program pretty much applies regardless of what criminal offense a person has committed, except for an offense in which someone is sentenced to life without parole. So outside of that small category, any offense could nevertheless be committed by an offender, and they would still be eligible to participate in the program. So that point, I guess, is what led to S18, and that is Justice Oversight has talked about this over the last year, which is that the right policy? Is the policy correct that it should sweep that broadly? And so the proposal in S18 is to carve out a category of serious offenses, which are described in the bill as disqualifying offenses, and say that group of folks, if you've committed one, and there's a list of 8 offenses, which we'll get to when we look at the language. But for that group of folks, if you committed a disqualifying offense, then you don't necessarily become eligible for the good time program. You have an opportunity. You can petition the court to participate in the program, but it's not automatic. As you saw the language you just looked at, for everybody else, it's automatic. You automatically participate. But for the, oh, thank you, Peggy. That just came up on the screen.
Eric?
So if,
yeah, who was that? Senator Bruce?
Yes. You paused for a second, so I jumped in, but I'm just wondering, this uses the phrase disqualifying offense throughout, and it waits until the very end to define it. Not sure why that would be. Wouldn't it make sense to define it at its first usage or before its first usage?
It's certainly an option. It's pretty common for definition sections to come at the end of a section. It's also not uncommon for them to come at the beginning. So there's really not a right or wrong answer to that. Sometimes when a statute is being amended, in other words, if we were to put it at the very beginning, there is no definition subsection in the statute as it's written right now. That would mean you'd have to re-letter and renumber everything, which sometimes can cause problems with cross references, that kind of thing. You know, when you're starting from scratch, sometimes you put the definition subsection up front because you wouldn't have to do that. That's not to say it's not possible. It certainly could be done.
Yeah, and I wouldn't, if it's any trouble to do it, I wouldn't suggest it. I just asked the question because in most contexts, when you use a word that's unfamiliar or being given a new definition, you define it and then you go ahead with it. But it seems like within your profession, it's done differently. So.
Yeah, but it certainly could be done either way, and sometimes it is. As I say, it's really more a matter of not wanting to create any inadvertent consequences by relettering an existing statute. But on the other hand, this particular statute's only been on the books for 2 years, so probably have run into fewer problems by doing that. So certainly possible. So anyway, yeah, in the big picture, Peggy, can you page down by any chance the language? I was trying to do it from my end, but go down to page 3. Thank you. And you see at the bottom there, so this is where the notion of the disqualifying offense that Senator Bruce was just referring to comes into play. So if you committed one of these disqualifying offenses, then the bill proposes that you be treated differently. In other words, you don't automatically qualify for the good time program. And it divides the group of people who have committed a disqualifying offense into 2 categories. One is you're already in DOC custody at the time this bill is passed. So if you're an inmate, or if you're in DOC custody when this bill becomes law, that's one category. And the other category is, well, you are someone who's charged in the future with a disqualifying offense. So it depends on the timing. You're either in custody or you're charged in the future with a disqualifying offense. If you're in custody, category 1, if you're in that group of people, if you're already in an inmate or under DOC supervision at the time that this bill becomes law, if it does, then you don't earn good time going forward. And it's pretty much cut and dry. That's the proposal for that group of people. If you're already in custody, then going forward, you don't earn any good time in the future if you're in custody for one of the disqualifying offenses. Now, the language makes clear that it doesn't. If you've already earned good time, you already have by the time July 1st or whenever the bill is signed. If you have already earned good time in the past, then this bill doesn't do anything about that. You can't take away somebody's good time that they've already earned. They keep that, but they don't earn any more in the future. So that's that particular group. If you are someone who's charged in the future, if you could go down to page 4 now, please, Peggy. If you're someone who's charged in the future, you see this is subdivision 6 on page 4 with a disqualifying offense. Well, then as I say, the default is not that you automatically are able to participate as it is with other offenders, but you can petition the court for the opportunity to participate. And you see the language is, if the court, you essentially file a petition seeking to participate in the program, and if the court makes a finding that your participation would serve the interest of justice without unreasonably affecting public safety, then you can participate. But if the court denies your petition, doesn't make that finding, or if the defendant never files the petition in the first place, then they're not eligible to participate in the program. So the default for that group of people having committed the disqualifying offense is that you don't participate, but you can petition a court for a finding that permits you to. And that's the structure of it. The last piece you can see is the definition that Senator Bruce was referring to. And this is, well, which offenses count as disqualifying offenses that remove a person's ability to participate in the program potentially without that court finding. And there's 8 of them you can see. There's arson, murder, manslaughter, kidnapping, L&L with a child. You see subdivision 6, this is something that had been discussed earlier. That's sexual assault, but it's only sexual assault that's based on lack of consent, threat, coercion, the administration of drugs to a person to impair their ability to consent. So it doesn't include what, for lack of a better term, we might call statutory rape or sexual assaults that are particularly based on the age of the victim. So if it's that category of cases is not included here, but if it's lack of consent, threat, coercion, that sort of thing, they are also count as a disqualifying offense. And the last 2 are aggravated sexual assault. The last one is aggravated sexual assault of a child, number 8. And that also is a disqualifying offense that makes someone not automatically eligible for the good time program. So that's the proposal. As I say, essentially in the big picture, it carves out 8 offenses, disqualifying offenses, that removes them from the automatic participation in the good time program, and going forward allows those defendants to petition the court for participation. But if the court doesn't make a finding that they can, then they don't earn good time the way people who commit other offenses are able to earn it. I think that's kind of the description and walkthrough in a nutshell.
No, good job. Senator White.
So why do we exclude people who are on probation and parole? Because they are under DOC custody, but they have no right to earn good time?
Right.
Why?
But the probation is a different issue.
But why
currently they never have. They're not incarcerated.
But they're under the custody of DOC.
I think that was it, Senator Sears, that they had never participated before, even when the program had been in place prior to 2005. And I think it was a supervision issue. They just don't have the same opportunity to meet the requirements of the program that someone who was incarcerated would. And I think there was a logistical problem as well that probably someone from DOC could answer better than I, but I think there was a logistical problem with their participation also. But I don't think that's any different than what had been before.
No, I realize that probably, but I would like to hear the justification for that, because it seems to me that if somebody is on probation and parole, that they are under the custody and they have to check in, I don't know, weekly, daily, whatever their things are. And if they don't do anything, if they're compliant and doing what they're supposed to be doing, they're doing the same thing that they're doing.
Actually, we will be taking.
Huh?
We can have somebody explain on the parole part, but we will be taking up the issue of probation later this session. But good time has always been for behavior within the confines of the correctional facility. And the furloughs are able to receive it, but once you're on parole, you don't get good time. And it's never been that way. So it's not a.
I'll wait for the explanation. Or the justification, rather.
But we are dealing actually with probation. That was part of justice reinvestment. Senator Baruth has a question.
I guess my question goes to the other end of it. So as I remember, when I think it was the head of corrections was talking about this as a behavioral management tool, and it gave the system a way to manage behavior of people who are incarcerated, especially longer term. And so I'm wondering why we're getting back in the business of carving out offenses because it's, and anybody should feel free to correct me if I'm wrong in any of this, but these are the people with the longest sentences, it would seem like. And so we're taking away a management tool, even though they're going to be with us the longest. And it seems like good time isn't something that would drastically reduce their sentence, but it would allow us a management tool with them for the long term. So I'm not opposed to it. I'm just wondering what the logic is, or if it's, I know the victims' rights community were against good time for this category of offenses.
Well, actually, we did not hear opposition last year when we passed the bill. There was Chris Fennell will be on later, but she did provide us with a letter last January expressing extreme concern about how victims would be notified of the changes in the good time law. But we did not hear from the Network Against Domestic Violence and Sexual Assault. last year when we did the bill. And a number of victims, families of some of the most horrific crimes in Vermont history have contacted various individuals once they got an email from the Department of Corrections. The Attorney General, who is our next witness, as actually this is his bill. I've sponsored it in agreement with him that we need to deal with this issue and hear from the victims community, but also hear from others on the subject. So I'm going to turn it over to Attorney General Thomas J. Donovan to discuss the bill and the issue. And I wouldn't have put my name on it if I didn't agree with it, but I want to make clear that this is really the genesis of discussions that he and I had, and he's will explain why.
Well, thank you, Senator Sears, and good morning to the committee and Happy New Year to everybody. TJ Donovan, Vermont Attorney General, for the record. Senator Sears, I want to thank you for your leadership and your willingness to sponsor this bill. You're absolutely correct. I did reach out to you after I was contacted by victims and victims' families. And I want to be clear, it wasn't just victims who I did not know. It was victims and their families who I have a personal relationship with from my time as state's attorney in prosecuting the perpetrators of really horrific crimes against their family members. And that was, as Senator Sears, the genesis of attempting to amend this bill, I should say this law. And Senator Sears, I want to thank you again for your willingness to listen, your willingness to lead on this. I want to thank the committee too for their leadership on this issue. I want to be very clear. We supported this bill. It's the bill that was passed into law. I don't do well with numbers. I can't recall the exact number. And specifically on good time, I support good time as a policy. It makes a lot of sense to incentivize, I think, as Senator Bruce indicated, to incentivize people's good behavior and to do their programming while incarcerated. Because as I've always said, the thing about jail for the vast majority of people in it is they're going to get out. And it's in our collective public safety to make sure that when they get out, they have the tools necessary to be law-abiding, productive citizens. That is the essence of public safety. That being said, there is a subset of, I think, the most serious cases that have been previously adjudicated. And I think this is the compromise that the bill strikes to balance. Those crimes that, I guess, as Eric has called them, disqualifying offenses, murder, manslaughter, arson with death, including kidnapping, LNL, lewd and lascivious conduct with a child, sex assault, aggravated sexual assault, and aggravated sexual assault with a child. These are the most serious cases that those that have been adjudicated, oftentimes, I would argue probably 95% of the time, by a plea agreement where prosecutors have made representations, where courts have made statements that victims and their families have relied upon. That this person who did an incredibly horrific thing is going to serve this sentence. And I know that those victims and their family members have relied upon those promises, those representations by us as prosecutors, as officers of the court. And I'll take full responsibility. As I said, we supported this bill and this law. And I did not think deeply enough at that time about the impact it would have on victims. And I was wrong. And I need to remember those conversations. And I do remember those conversations that I've had with so many victims as my time as state's attorney. Ned and Joanne Winterbottom, who I know have sent a letter to the committee, whose daughter, Laura, was brutally murdered in City Hall Park in Burlington. Gerald Montgomery was the person who was responsible for that murder. That case was resolved by a plea agreement. And when you reach a plea agreement, as a prosecutor with the defense, you always, of course, include the victim and the victim's family. And you tell them things that this is what this agreement is. And that's exactly what that plea agreement is. It's an agreement that this is what's going to happen. And I can't speak for the Winterbottoms, but I know, as Senator Sears indicated, and along with so many other families, they were completely caught off guard by this and getting contacted by DOC. And I think we owe it to them to fulfill our agreement, to stand by the promises we made for this subset of cases that are the most serious, that have impacted, if people have lost their lives, have been brutally murdered, where another case, another family that I consider to be personal friends of mine, and that friendship developed through the prosecution of the case, of a young girl who, now a woman, assaulted at a sleepover. I mean, these cases, I don't, they come back to me, and I remember and know the impact it had not only on her, but her family. That case went to trial, convicted, and through some procedural developments in the case, a charge was dismissed and went back, and there was a sentence. And again, for that now woman, but young child at the time, they relied on that sentence and on that certainty. And again, I can't speak for them, but I know that it gives them the peace of mind and the comfort and the reliability of the integrity of our system, that these sentences that were agreed to, that were imposed, are exactly what is going to be said is what's going to happen. And so I think out of the integrity of the system, out of standing up for victims, making sure that the credibility of the court, of prosecutors, that when we say things are going to be agreed upon, that we follow through on those. And I think this bill strikes that compromise where we're not saying, hey, you never get good time. As I said, the policy of good time is an important public policy, and I support it in concept. Of course, we want to incentivize people's behavior. And I understand people have a right to serve their sentence, get out, and be productive citizens. But I think this subset are the most serious of crimes, and it's a limited group. And I think if you've been previously adjudicated, if promises and representations have been made, the state has to stand by those. And that's why these should be disqualified from accepting a good time. If going forward, there are others that are convicted of these serious crimes, I think the amendment does a good job laying out a process where they can petition the court, where certainly victims will be notified and be part of that process. And so I think this amendment, as I said, is good public policy. It's a good compromise. It stands up for victims and their families. It is in the interest of public safety, and it's something that I support. So Senator Sears, again, I want to thank you for your leadership and your willingness to listen to not only my concerns, but the concerns of so many victims and their families. I think this is the right thing to do. Our words need to matter. I take responsibility for not thinking as deeply about it as I should during last session. But when you're wrong, and you got to admit it. I was wrong on this, and that's why we asked Senator Sears to submit this amendment. So I ask that you support the amendment, and I ask that that this law, in fact, be amended for this express purpose. And I'm happy to answer anybody's questions.
Senator Benning.
Thank you, Senator Sears. TJ, first, let me say I appreciate your acknowledgement in a mea culpa moment. That's a refreshing change of pace from some of the political speeches going on these days. And we don't hear those kinds of things often enough, but I think it's a great opportunity for civil discourse. I'm curious, I support on the top, I have two questions actually. One of them has to do with eliminating carte blanche every opportunity for anyone convicted of these offenses. I very much sympathize with victims who deserve to have a finality, if you will, in these most heinous offenses. But I'm curious if there are victims who have reached a conclusion somewhere down the road that circumstances have changed and they acknowledge that the person who's still in jail really shouldn't be there any longer. Should there be some kind of an exception for that possibility?
No.
Well, Senator Benny, I appreciate first your comments, and I appreciate your public comments on what's going on in our country, and I appreciate your leadership. I can't speak for victims. As you know, this is such a personal and unique experience that victims go through when they have been violated, and for their families. And Senator Benny, I know is your role as an attorney and having been in the courtroom during these negotiations, I certainly learned in my time as state's attorney that I began to say that whatever the sentence is not going to heal the physical scars, and more importantly, will not heal the emotional scars that so many victims have suffered as a result of these horrific crimes. So I understand your question, but I can't speak for victims. I think this is such a small subset of cases. And it goes back for me that they relied upon our representations. And I guess I would ask to hear from victims directly, to your point, whether or not they may feel that way. I just, out of respect for them, I don't want to speculate, but I understand your point.
No, that's fair. I just wanted to know whether or not if we pursued something like that, would you be carte blanche opposed to it? Let me tell you my reason for asking. A fairly close family member who was serving a long period in jail. It wasn't for one of these particular offenses, but it was a situation where many years into his jail sentence, further analysis of what he had been convicted of led another personal family member to go and interview virtually every one of the alleged victims in his offenses, only to learn that many of those people, if not all of them, were stunned that the other family member had entered into a plea agreement that had him still in jail after so many years. I'm just looking at a possibility that even on one of these offenses, if a defense attorney came to you with a petition that was signed on board by the victims in that case, should there be an available avenue even for those who are convicted of these offenses? And I guess I'm not going to ask you to answer directly whether that should be the case. I'm only going to plant that seed with you, and we'll move on from there. My second question goes back to Jeanette's comment about people who are on probation and Philip's statement that this is a management tool. I agree, it is a management tool because I think people in jail see a light at the end of the tunnel that they should pursue. But people who are on probation, if given the same opportunity, it seems to me probation would now have a management tool and hopefully decrease the number of violations of probation that are out there. And I'm just thinking, if we have that as a possibility in this bill, would you be opposed to that?
I don't think I'd be opposed to the probation status. And I think what's important is, as you know, in the courtroom, we always would joke about corrections time because it would be hard to follow and hard to understand. And what underlies it is the status of the offender. Obviously, probation is a different status where technically the clock is not running, right? It's not a 2-serve sentence as opposed to furlough. And then you have the split to serve sentences. And it's confusing for people. And I think what underlies this amendment is the clarity to victims about what people are going to serve. And I think if we're talking about probation, frankly, we are talking about a different status and a different level of offender. Because if you're getting probation, by definition, it's not going to be as serious, generally speaking, as these 8 crimes. And so that is something that, of course, I'd be willing to take a look at. And I think would be open to be supportive on the probation status.
On the probation status, with the Justice Reinvestment 2 working group finished our work Monday. We are preparing a report, and part of that report will be a bill that Bryn is working on right now that would change the way we do probation. And so we will be taking that up shortly. It's just a matter of getting it introduced, and we wanted to wait until the committee, Justice Reinvestment 2 working group is working. There were 2 proposals. One was to add good time to probation. Another was to follow a Montana law that provides for an accurate review of probation where the default is you're off after serving half the time if there is no reason to keep you on probation. We can get into this later, but technically, most people have violated probation in the first 7 months of the probation term. They rarely violate after that. Just as in the juvenile system, you have a midpoint review or a yearly review, I think it is, to see if they should stay in custody of DCF. This would be similar to that. But we did discuss the good time for probationers. That was determined that would be extremely difficult to determine, but we'll get into that shortly.
Thank you.
Senator Baruth, then Senator Nika.
TJ, thanks. I appreciate the comments you make about the victims. I'm reminded of Senator Leahy when he was talking about the Violence Against Women Act, and he was talking about cases he had prosecuted 20 years earlier, and they were still with him. So it's not, victims and their families are obviously the largest sufferers, but everybody who's involved with that, as you've been, carries those marks with them. I don't mean at all to downplay that, but I am wondering, your justification for the bill is almost entirely the representations that were made to families in plea bargain agreements.
Yep.
But obviously there are plea bargains that are made outside these disqualifying offenses for other offenses, and potentially more than are represented here because these are the rare crimes. So it seems to me what you're making is an argument against good time itself, rather than this subgroup. The other thing that I wonder about is when we made this change in the law and the statute as it now stands, no one should be misrepresenting that to families from that point forward. Any plea agreement should make clear that because the law says everyone is entitled to good time, anybody from last year forward should be being told that good time is a possibility. So it seems like what you're talking about is a retrospective group of people who weren't told that. So I'm curious why it wasn't constructed as everybody going forward and then carving out those crimes that had happened before the date of that act.
Sure. I'm not sure, Senator, if I completely understood the question. So I'll just explain my thinking on this bill. I do think good time is, as I said, good public policy to incentivize people's behavior. And it should also be noted that the vast majority of cases, criminal cases that are adjudicated, are done by plea agreement. No question about that. But I think when we're talking about public safety, we have to be reminded of victims' rights. And this is a compromise that these, in my opinion, are the most egregious, the most serious cases that have occurred or could occur in our state, that those that have been previously adjudicated, done by a plea agreement, we owe it to the victims to stand by our representations. Hence the 8 cases that if you've been previously adjudicated, you don't get good time. Understanding to make sure that this is constitutional, that going forward, that there is a process in place and almost a tiered response based on the seriousness of the offense, that if going forward you're convicted of, let's call it the big 8, the serious cases, there is a process in place through the court where you may petition.
I think PJ just froze.
I can see him fine.
Yeah.
Can you hear me?
Yes.
Yeah.
I think it might be on Jeanette's end.
Okay. That there's that process in place going forward that allows offenders to petition, but also gives victims the avenue to appear. And I think to Senator Benning's point, object or not object. But I think this 8, for those that have been adjudicated years ago, it's important that we stand by the representations. I don't know if that answered your question, but I don't know if I...
Well, it does. I mean, in other words, my point would be if someone was the victim of a more or less standard assault, so they're in a bar and someone punches them and destroys their cheekbone, it wouldn't come under these headings.
Right.
But there might be a plea bargain made with their family. It might be traumatic. They might, hang on to that representation in exactly the way you're talking about. It's just that they wouldn't be covered by this bill. So I see what you're saying. You're carving out some and not others.
Yeah.
And I guess it reminds me of life without parole, the discussion we had there, because we talked about life parole as a concept that was either conscionable or unconscionable. And I came to the conclusion myself that it was unconscionable, but then we effectively said that there would be some carve-outs where we would still allow life without parole. And I find myself uncomfortable with those compromises because they run up against the fundamental principle at work. So I take your point, representations are important to victims, but going forward, if we didn't pass this bill, no one would be under the delusion that good time wouldn't be an option. In other words, everybody going forward should understand and be told that good time could be a part of what happens. So it does seem to me we're talking about this retrospective group of representations, and it does seem to me that there would be another way to address that besides the avenue pursued in this bill. But I take what you say about the very serious nature of the crimes, and I'll reserve opinion on where this goes. But that's my only concern about it.
Senator Nick, I'm sorry, TJ, go ahead.
I was just going to say, Senator Booth, I understand the concern, and I would just offer that, these are the most serious. And I think, there's no uniformity or standard approach to resolving other cases. And I would why other cases or charges were not included in this, because a lot of that's not going to result in jail time. You're not going to have jail time. And I think we as a state have moved away from over incarceration, have tried to reduce incarceration while enhancing our public safety. I give great credit to this committee, Senator Sears in particular, for a lot of those initiatives. And so when we look at who's in jail, It's the serious stuff, as it should be. And this is that carve out of these cases that, in my opinion, are the most serious, where those representations have previously been made to victims, and we need to stand by them. And it is a compromise. It is a compromise, as you noted.
Senator Nitka.
I'm just looking at section 6 on page 4 or 5, the last sentence in that section where it says, if the court denies the petition, or the big thing is, or if the defendant does not file a petition at sentencing, they shall not be eligible to earn good time under the section. I certainly understand if the court denies the petition, but if it's simply because the defendant, not necessarily wanting to take care of them, but does not file a petition at sentencing, what if they are just stupid, or they, I agree if you're defending yourself, you need to know everything, but, or their lawyer forgets this, they are not eligible. So there's going to be potentially two groups of people in here. One group that is eligible always, and then the other ones, not always, those who are denied wouldn't be, but the other ones who were basically too stupid to file the petition at sentencing. Why is that does not file at sentencing in there for those people?
I think you want to know, again, getting back to that representation, Senator, at sentencing, where the sentence is imposed, not only for the offender, but frankly for the victim, what the sentence is going to be. And I think people need to know and have a right to know what they can expect. And as a victim, if you've been told that somebody's going to serve X amount of days or months, you're going to rely upon that. And if we have a formula that reduces that sentence if things are done, we need to make the best efforts, I think, at the time of sentencing, right? Because here's the point of the criminal justice system that, frankly, we don't do well. When the case is over, we move on. And in very few cases, you don't have the continued relationship with the victims. And I've done defense work with your client, the offender. You go on as the practitioner to the next case. And that's why it's so important about the representation, that people have to be able to reasonably rely upon it. And again, I got it wrong that's why this amendment is important, because we moved away from allowing victims to reasonably rely upon not only what prosecutors like myself said, but what courts have imposed. And from a state perspective, that gets to the integrity of our state.
Let me try to just, before Senator White, let me try to just.
Can I just go to the first sentence there in 6 where I think that's what's a little bit misleading because of how that's worded, and then these words are down here. It's referring actually to two different things.
I don't have the bill in front of me, so I apologize.
No problem.
Go ahead, Senator Nitka.
No, I'm all done. That's all right. I'll check it out with Eric.
If I could summarize, there seems to be two concerns. One is, why even go prospectively? Because people that are sentenced under this change would know that good time's a possibility. And so that would be part of the negotiation during the plea agreement or during the trial, or whatever. That's one issue that's been raised. The second is, why is there no opportunity for those that are already sentenced to petition to get good time? Is that what I'm hearing from the committee? Those two?
Not from me on that, but that's certainly an issue.
Senator White?
So I understand, TJ, your how you feel that people need to be assured that things aren't going to change, but things do change. And if we don't have any ability in there for change to happen, then I don't understand at all why you would limit it to people who filed their petition at the sentencing. I mean, if I were a defense attorney, I would file it for every single person that I represented. I mean, it would be automatic. File this for everybody, because and things do change. People change, and just Joe's example of the family member. I think that we're by being rigid around this, we are working in opposition to the Justice Reinvestment 2 that we've been working on, which is trying to be more individually focusing on individuals instead of the absolute and the rule. So I have real concerns about why we would be so rigid in this. Just
Any other comments before we, yeah, DJ, go ahead. If you want
Yeah, Senator White, I appreciate that concern and understand. What's not going to change is Laura Winterbottom's not coming back. She was murdered. What's not going to change are the anxiety and the trauma that victims have experienced. And that's why the representations are so important for this subset of crimes, because they're the most serious.
I get that, but I also know that people change. And when we were looking at the, for example, at the life without parole, and we heard from victims, and we heard from the guy from California who actually formed a bond with the person that had killed his son, because he said this person was in a bad place, and I know that he's changed, and I know that things change, and I just think that being so rigid is, I like Joe's idea of having some kind of a petition or an avenue to petition. But anyway, that's because people do change, both victims and perpetrators.
And I appreciate that. And I do believe the committee, look, I can't speak for victims, and I won't do that. And I think you'll hear from some folks, but look, Senator, I understand your point. I know these people, they're good people, they have suffered, and they continue to suffer. And I think we need to listen to them. And that being said, I appreciate your concern and the concerns of the committee, and we stand ready to work with you. And I just appreciate the willingness that the committee is listening to this proposed amendment.
Thank you, DJ. Mr. Attorney General, thank you very much. Our next witness is
Thanks for having
Chris
me.
Fennell. Thank you. Chris Fennell from the Center for Crime Victim Services. And I doubt we're going to get to the other witnesses that were scheduled this morning. So Peggy will have to pick up with them on Friday morning, and that will push back some of the other testimony. I apologize. We do our best scheduling.
Thank you very much. I appreciate being able to testify on this really important legislation. I too, like TJ, supported this last year. And it was in retrospect that I saw unintended consequences and what that effect was having on victims and their families, especially for violent crimes. As the committee is well aware, one of the center's statutory responsibilities is to advocate for the rights and needs of Vermonters who have been hurt or harmed by crime. And it is in that context that the center supports exceptions this legislation would provide for offenders of violent crimes. The new language is proposing 8 crimes that would disqualify a person from earning good time. I want you to just think for a second what the very name earned good times means. It means that somebody who is a victim of a horrendous crime, or their family members in the case of murder, are faced with this person being able to earn good time. And the very words earning good time often trigger victims and their families because good and time do not follow their experience of this person. The issue, so that's one thing, but the issue of continues to be of notification, and that is problematic. People were notified by VANS, the Victim Notification Program. It was an email or a voicemail or a robocall. And I do believe there still needs to be more thought put into assisting, that was my cat, assisting corrections in figuring out a more personal way to notify victims, whether or not they have particularly signed up for VANS. I heard from a number of families. It is because of their reaching out to me that I was able to see that exceptions needed to be made. I believe the committee would also benefit from hearing their experiences and reasoning behind wanting exceptions. I encourage the committee to make these exceptions and would sort of end my testimony by saying, I actually worked in victim services for many, many years, 25, 30 years. And while everything appears to be done on behalf of the person who is being charged, victims are often left out, they're silent, there really is no justice for them. And things can't go back to how they were or what they were. But I think, especially with these horrendous crimes, they should not be eligible to earn good time. And I can't say that strongly enough. I worked with people who literally had calendars to mark when the person was getting out of prison. And in some cases, it was 20 years. One case, it was 32 years. And they figured in 32 years, they'd have to move because they didn't want to be found. So, this is something that victims carry with them. And certainly, they move on with their lives. But in the back of their brains is always knowing this person, they could see them again. And knowing that they make some kind of adjustment or change when that time comes. And it's very sad that I say that, but it is true. 10 years sounds like a long time. 20 years sounds like a long time. People think that's my sentence until I get to go start another life because I'm still afraid. So I would encourage you to support this bill. I think it is an important bill. I'd also encourage you to invite some of the families who have acted by these violent crimes to testify. And I can certainly take any questions.
You're muted, Dick.
We do plan, thank you. We do plan to hear from some victims. And I was, as I always do, announcing that anyone who wants to testify to contact Peggy Delaney, our committee assistant. So I do plan to hear from some victims. I think the two real questions here is, as we move forward, should there be some method for those? The real problem is those that are already sentenced. Those that are, and I separate those two groups out. Should we be doing this to those that have not been sentenced? Those who, the victims, and everybody would be aware of the system, the change. Because when we did away with good time, we did away with good time for those who had already been, who were to be sentenced at a later date. It was called truth in sentencing. We did not take away good time from those that had already been incarcerated and were receiving good time. So the question is that group of people who are incarcerated for these crimes currently, who have rather lengthy sentences. Some may be closer than others, but that group, and then the group moving forward. So I think the focus of the committee, as I understand some of the questions and concerns, are that I think we understand those that have already been sentenced, but should we be considering it for those currently? I mean, who will be sentenced in the future?
And I would say in response to that, Senator Sears, that I think it is problematic for these horrific crimes. And I really do believe that in the midst of sentencing, the last thing victims need to hear is somebody's ability to earn good time and have that explained by the state's attorney of what that would mean to this sentence.
Okay. Senator White and then Senator Bruce, I think.
I just was going to ask Chris if, I don't know if you heard Senator Benning's story here, but if you had, because people change and victims change and offenders change and life changes, if you had, should there be some kind of an ability for an off-ramp isn't the right word, but some kind of an avenue for a victim to go and say, I believe that this has been long enough. I am no longer afraid, or whatever it is. Should there be some kind of an ability to have that avenue for reconsideration?
And I would respond to that, Senator White, by saying, I don't believe there should be. I did hear Senator Benning's story. And I do know and have known a number of victims who have gone through a reconciliation process. And in another state where I worked, one of the things that happened was that, especially these horrific crimes, if victims wanted to meet with the person because they needed to do that as a process of their healing, we would have to look at what kind of supports they had, all kinds of things, to decide whether they could or could not go to the prison and have a session where they could talk. I bring this up because there are very dangerous people in the world, and there are sociopaths in the world and psychopaths. And I wish that were not the case, but there is. And I don't believe they should ever be able to earn good time.
Senator Baruth.
So, Mr. Chair, you very correctly summarized one of my set of thoughts about this. The bill already on page 4, it segments out the offenders into those before the date of enactment and those after, in terms of eligibility for this petition. So it seems to me the thinking is already there in the bill about looking at this at 2 points in time, prior and post. I still am of the opinion that the argument about plea bargain agreements needing to mean something doesn't mean anything after the date of enactment of what we did last year, because all representation should include the way the law currently reads, which is that everyone is eligible for good time. So it seems to me, in line with the victims' rights testimony and TJ's testimony, that we could speak to people who were sentenced prior to that date and exempt them from good time. But the argument that we shouldn't have good time because it might trigger a victim because of the words good time, I see how that might be the case. But I think such a person might conceivably be triggered by the understanding that the perpetrator who is now in jail is being allowed any privilege of any sort. And it's the fact that they're being notified about this, which was an attempt to to provide something of value to the victims' rights community, that they're finding out about this. So, you know, if that's the argument, then maybe we should change the name from Good Time to something neutral. And I think maybe given the fact that good times means something almost joking, maybe we should think about that. But I would favor taking what the bill already does, which is looking at those sentenced before the enactment of last year's bill and those sentenced after, as a way to think about this.
I want to remind everybody that last year, it was not last year.
Well, whenever we passed
Well, it was last year, but it wasn't that long ago. It was in 2020. So when we passed the legislation, there was a debate about making it retroactive to the whole sentence, and should they go back to when they started incarcerated. And we decided to not start it until January 1st of this year. So I want to make clear to everybody that we're not going back. So if the person had been sentenced for 10 years, they're not getting 10 years worth of, we're not asking the department to look back and see if each month they had would have accumulated that time. That these individuals will be getting their good time beginning January 1st. So it will accumulate this month, but it wouldn't. It doesn't go back to 2020, 2019, 2018, etc. Are there any other questions for Chris or comments from the committee on the bill before we? Yes, Joe.
Chris, I want to say I appreciate your comments, and I don't want to give you the impression that I am not sympathetic. In fact, I support this bill, and if it comes out exactly the way it's written, I'm perfectly fine with that. I have this thought, one of our most successful programs, at least it's being touted as such, is the restorative justice program, where there's an opportunity for victims to come in and look somebody square in the eye and say, this is what you did to me, and I don't appreciate that. And all parties come away able to contemplate what just happened. What I'm somewhat concerned about is a complete cutting off of any possibility, because I've experienced one of those possibilities and I know they exist. At the same time, listening to you, I recognize that there are people who could be triggered by that possibility being out there. I just don't know how to reach a middle ground. And I just wanted to leave you by saying I appreciate what you're saying, and I hope you understand my contemplating is not meant to dismiss what you're saying.
Absolutely. Thank you, Senator Benning.
Thank you, committee. We'll pick up tomorrow morning at 9 o'clock. But when we come back on Friday morning, we'll hopefully hear from Flacco Schilling and Sarah Robinson from the network, and then others who've been scheduled. We probably won't get to everybody who's been scheduled for next Friday in the time allotted. So Peggy and I will work on that for Friday morning. When we come back to